Welcome back to SCOTUS Oral Arguments and Opinions. In this episode, we'll discuss two blockbuster emergency docket rulings that reveal fundamental tensions about presidential power, judicial authority, and constitutional rights in the Trump era. Please note that this summary is read by an automated voice. Both cases landed on the court's emergency docket within weeks of each other, and both expose deep philosophical divisions among the justices about when courts should intervene to check executive power. What makes these cases particularly significant is how they demonstrate the court's willingness to grant extraordinary relief to the government while leaving lower courts and affected individuals to grapple with the consequences. First, Trump versus American Federation of Government Employees. Can the president unilaterally restructure the federal government through massive workforce reductions? Or does such sweeping reorganization require congressional authorization? The court said the president can proceed with planning these reductions while the legal challenges continue. Justice Sotomayor joined the majority, but emphasized that courts can still review the actual implementation plans. Justice Jackson issued a scathing dissent, accusing the majority of enabling an apparently unprecedented and congressionally unsanctioned dismantling of the federal government, and suggesting the court has become too willing to greenlight this president's legally dubious actions in an emergency posture. Second, Department of Homeland Security versus DVD. When the government wants to deport someone to a third country not mentioned in their original removal order, what constitutional process is required? The court twice intervened to help the government, first staying a district court injunction that required notice and hearings, then clarifying that related court orders were also unenforceable. Justice Sotomayor issued blistering dissents in both rulings, documenting what she called the government's unprecedented defiance of court orders and accusing the majority of bending the rules because the administration has the Supreme Court on speed dial. Both cases raise profound questions about the balance between executive efficiency and constitutional rights, and both reveal a court deeply divided about its own role in checking government power. Let's now go deeper into the government reorganization case. Trump versus American Federation of Government Employees. Can the president unilaterally restructure the federal government through massive workforce reductions? Or does such sweeping reorganization require congressional authorization? This case emerged from President Trump's Executive Order 14210, which directed federal agencies to conduct critical transformation through large-scale reductions in force and eliminations of functions the administration deemed unnecessary. Lower court rulings. The district court in California examined extensive evidence and granted a preliminary injunction blocking the order's implementation. The court found that historically, presidents have sought congressional authorization before undertaking major government reorganizations. The most recent such authority expired in 1984. The Ninth Circuit refused to stay that injunction, allowing it to remain in effect. Both lower courts concluded the challengers would likely succeed in proving the president lacked authority for such sweeping changes without Congress. Supreme Court decision. On July 8, the Supreme Court reversed course. The court granted the government's stay application, allowing implementation of the workforce reductions to proceed during appeals. The majority found the government likely to succeed on the merits, concluding the executive order and implementing memorandum were lawful. What stood out here is how the court framed its decision. The majority emphasized they expressed no view on the legality of specific agency reorganization plans themselves. The court focused solely on whether the executive order directing agencies to create such plans violated the law. Justice Sotomayor's concurrence. Justice Sotomayor joined the majority, but with important caveats. Sotomayor agreed with Justice Jackson's core principle that presidents cannot restructure federal agencies inconsistently with congressional mandates. However, Sotomayor found a crucial distinction. The executive order specifically directs agencies to plan reorganizations consistent with applicable law. The implementing memorandum from federal management offices reiterated this same legal constraint. Sotomayor emphasized that the actual reorganization plans aren't before the court yet. The stay preserves the district court's ability to review those specific plans when agencies submit them. This approach allows lower courts to examine whether implementation actually complies with legal requirements. Justice Jackson's scathing dissent. Justice Jackson sharply criticized the majority. Jackson described the court's decision as not only truly unfortunate, but also hubristic and senseless. Jackson opened with constitutional history. Over the past century, presidents attempting to reorganize the federal government first obtained congressional authorization. Between 1932 and 1984, Congress granted reorganization authority to 9 different presidents from both parties. What made Jackson's dissent particularly cutting was the accusation about patterns. Jackson wrote about this court's demonstrated enthusiasm for greenlighting this president's legally dubious actions in an emergency posture. The dissent attacked the court's fact-finding approach. Jackson argued the court operates from a lofty perch far from the facts or the evidence, and lacks capacity to override reasoned lower court fact-finding. The district court had examined 68 sworn declarations totaling over 1,400 pages of evidence. Jackson's most pointed criticisms. Jackson deployed vivid metaphors to criticize the majority. The dissent accused the court of allowing the president to release the president's wrecking ball at the outset of this litigation. Jackson characterized the decision as permitting immediate and potentially devastating aggrandizement of one branch at the expense of another. The dissent argued this leaves the people paying the price for reckless emergency docket determinations. The constitutional stakes couldn't be higher, according to Jackson. The dissent warned about an apparently unprecedented and congressionally unsanctioned dismantling of the federal government proceeding before courts determine presidential authority. The fundamental disagreement. The core split centers on characterization. The majority sees routine workforce management within existing presidential authority. Jackson sees unprecedented structural overhaul requiring congressional approval. Both sides agree presidents possess personnel management authority. The question becomes whether Executive Order 14/2010 represents normal workforce adjustments or crosses into wholesale government reorganization territory. Sotomayor's concurrence attempts to bridge this gap. Sotomayor acknowledges constitutional limits while allowing the process to continue under legal constraints. The concurrence preserves judicial review of actual implementation. Broader implications. This decision affects millions of federal employees and countless government programs. The scope of proposed cuts includes reductions of 50% to 85% at various agencies. The case also reflects broader tensions about presidential power and emergency court intervention. Jackson's dissent suggests concerns about the court's emergency docket becoming a preferred avenue for controversial presidential actions. Both the majority and Jackson acknowledge this represents just the first round. Lower courts will now examine specific reorganization plans as agencies submit them. The constitutional questions remain very much alive. The ultimate resolution may depend on how agencies implement the executive order and whether they stay within existing legal boundaries. That's where the real battle will unfold in the months ahead. Let's move next to one of the most contentious immigration cases to hit the Supreme Court in recent years. Department of Homeland Security versus DVD. This case sits at the explosive intersection of immigration enforcement, constitutional due process, and the limits of federal court power. This case unfolded in real time before our eyes, with the Supreme Court intervening not once, but twice, in emergency proceedings that revealed deep divisions among the justices about fundamental questions of judicial authority and human rights, setting the stage. Let me paint the picture of how this case came to be. The Department of Homeland Security has been grappling with a complex problem: what to do with individuals who have final removal orders but cannot be sent back to their home countries. Maybe their home countries won't accept them back, or diplomatic relations have broken down. So DHS developed a policy of sending these individuals to third countries, places that weren't mentioned in their original removal orders. The plaintiffs in this case, represented by the initials DVD to protect their identities, are a group of people facing exactly this situation. These individuals argued that the government was essentially changing the rules of the game after the fact. When DHS decided to send them to entirely different countries than originally contemplated, the plaintiffs claimed the government needed to give them notice and a chance to argue they might face torture or death in these new destination countries. The constitutional question. Here's where the constitutional rubber meets the road. The Fifth Amendment guarantees that no person shall be deprived of life, liberty, or property without due process of law. Notice that the Constitution says person, not citizen. This case forces us to grapple with a fundamental question. When the government wants to send someone to a country where that person claims to face torture or death, what process is constitutionally required? The plaintiffs argued that basic fairness demands notice and a meaningful opportunity to be heard before removal to any new country. Think about it from their perspective. The original removal proceedings might have been years ago. Conditions in various countries change, and now the government wants to send them somewhere entirely different without any input from them. The government pushed back hard, arguing that these individuals had already received all the process the Constitution requires. The government's position was essentially, these people already had their day in court, they lost, and now we have broad discretion about how to execute their removal orders. The district court steps in. On March 23, 2025, the plaintiffs filed their lawsuit in federal district court in Massachusetts. Within days, they obtained a temporary restraining order. What happened next was remarkable. The district court certified a nationwide class and issued a preliminary injunction on April 18, 2025. Let me break down what that injunction required the government to do. First, DHS had to provide written notice before removing anyone to a third country. Second, individuals had to get a meaningful opportunity to raise claims under the Convention Against Torture. That's an international treaty that prohibits sending people to countries where they're likely to face torture. Third, the government had to use something called a reasonable fear standard and give people specific timeframes to challenge adverse decisions. The government immediately sought to have this injunction stayed, meaning put on hold, while the government appealed. But here's where things get interesting. Both the District Court and the First Circuit Court of Appeals refused to grant that stay. The lower courts were essentially saying, no, this injunction is so important that it needs to remain in effect even while the appeals process plays out. The Supreme Court's first intervention. Facing continued losses in the lower courts, the government took the extraordinary step of asking the Supreme Court for emergency relief. The government filed what's called a stay application on May 27, 2025, asking the Supreme Court to put the district court's injunction on hold. What makes this particularly dramatic is what had happened just before the government sought Supreme Court relief. On May 20, 2025, DHS had attempted to remove individuals to South Sudan, and the district court found this violated the injunction. The government was essentially asking the Supreme Court to rescue the government from a situation where the government had already been found in violation of a federal court order. On June 23, 2025, the Supreme Court granted the government's stay application. But here's what made this decision so controversial. The majority provided absolutely no explanation for the decision. No legal analysis, no reasoning, just a bare order staying the injunction. Justice Sotomayor's blistering dissent. Justice Sotomayor, joined by Justices Kagan and Jackson, was having none of it. Justice Sotomayor wrote what can only be described as a blistering dissent that accused the majority of endorsing government lawlessness. Justice Sotomayor documented a pattern of what Justice Sotomayor called unprecedented defiance by DHS. According to the dissent, the government had repeatedly violated court orders even while seeking relief from the Supreme Court. Justice Sotomayor argued that DHS had continued removing individuals without proper process, even after being enjoined from doing so. The dissent emphasized that the Fifth Amendment unambiguously guarantees due process to all individuals facing removal, regardless of their immigration status. Justice Sotomayor stressed that the government's position, that the government could remove people to potentially dangerous countries without any notice or opportunity to be heard, violated basic constitutional norms and international law. What's particularly striking about Justice Sotomayor's dissent is the language Justice Sotomayor used. Justice Sotomayor suggested that the court's intervention effectively endorsed the government's lawless conduct and undermined the rule of law. Those are not words justices typically use lightly. The clarification drama. But the drama wasn't over. After the Supreme Court stayed the injunction, the district court issued what's called a minute order. The district court said that while the Supreme Court had stayed the main injunction, a separate remedial order from May 21st remained in effect. This remedial order dealt with 8 specific individuals whom the government had tried to remove to South Sudan in violation of the original injunction. The district court was essentially saying the Supreme Court stayed the main injunction, but the Supreme Court didn't say anything about this separate order dealing with these 8 people. And here's the kicker. The district court cited Justice Sotomayor's dissent as authority for this position. The government immediately ran back to the Supreme Court, asking for clarification of the stay order. The government wanted the Supreme Court to make clear that the remedial order was also stayed and unenforceable. The July 3 Clarification Order. On July 3, 2025, the Supreme Court granted the government's motion for clarification. The majority held that the May 21 remedial order could not be used to enforce an injunction that the stay had rendered unenforceable. The court cited the principle that a reviewing court's stay order divests the district court order of enforceability. Justice Kagan wrote a brief concurrence. Justice Kagan acknowledged that Justice Kagan had voted against the original stay and continued to believe the court should not have stayed the district court's order. But Justice Kagan agreed that a district court cannot compel compliance with an order that this court has stayed. Justice Sotomayor's second dissent. Justice Sotomayor, joined by Justice Jackson, issued what can only be described as a scathing dissent that accused the majority of bending the rules for the government. Justice Sotomayor argued that the government's motion for clarification was procedurally improper because the government had not first sought relief in the lower courts, as required by the Supreme Court's own rules. Justice Sotomayor characterized the government's request as seeking to remove an obstacle to achieving unlawful ends, specifically sending 8 people to South Sudan where the individuals would face torture or death without any due process. The most memorable line from Justice Sotomayor's dissent was this: other litigants must follow the rules, but the administration has the Supreme Court on speed dial. Justice Sotomayor was essentially accusing the majority of giving the government special treatment and allowing the government to circumvent normal procedures. The broader legal context. What makes this case particularly significant is how it represents the first major test of class-wide injunctive relief after the Supreme Court's decision in Trump v. CASA just 4 days earlier on June 27, 2025. In CASA, the court fundamentally changed the rules about when federal courts can issue nationwide injunctions. Let me explain what CASA did. For years, federal district courts had been issuing what lawyers call universal or nationwide injunctions, court orders that stop the government from enforcing a policy against anyone, anywhere in the country. Critics argued this gave too much power to individual judges and encouraged forum shopping, where plaintiffs would hunt for friendly courts. In CASA, the Supreme Court said, no more. The court held that if plaintiffs want broad relief that benefits people beyond the specific plaintiffs in the case, the plaintiffs need to go through the rigorous requirements of what's called a Rule 23 class action. This means proving things like numerosity, commonality, typicality, and adequate representation. The DVD case was fascinating because it showed plaintiffs adapting to this new world. Instead of seeking a universal injunction, the plaintiffs sought class certification under Rule 23 and then obtained class-wide relief for the certified class. In theory, this should have satisfied CASA's requirements. The jurisdictional arguments. But the government argued that even this class-wide relief was beyond the district court's authority. The government raised 3 separate jurisdictional challenges, basically arguing that Congress had stripped federal courts of the power to issue this kind of relief in immigration cases. First, the government pointed to a statute that bars class-wide relief restraining removal operations. Second, the government argued that another statute channels all challenges to Convention Against Torture procedures exclusively to courts of appeals, not district courts. Third, the government cited a provision that prohibits district court jurisdiction over suits challenging the execution of removal orders. The plaintiffs countered that these jurisdictional bars didn't apply because the plaintiffs were challenging conduct that occurred after the removal orders were final, conduct that couldn't have been challenged in the original immigration proceedings. The plaintiffs argued that when the government decides to send someone to an entirely different country, that's a new action that requires new process. Justice Sotomayor's cross-reference. What's particularly interesting is how Justice Sotomayor's dissent in CASA specifically cited Justice Sotomayor's June 23 dissent in DVD to make a broader point about the practical difficulties of crafting narrow injunctions in complex administrative contexts. Justice Sotomayor argued that narrow injunctions can sometimes be impractical and create more problems than broad ones. Justice Sotomayor pointed to the DVD case as an example of how the risk of noncompliance is particularly stark where the challenged action itself reflects an utter disregard for settled precedent, and given the government's repeated insistence that the government need not provide notice to individuals before their sudden deportations. The broader implications. This case raises fundamental questions about the balance between individual rights and government efficiency in immigration enforcement. It also highlights tensions between different branches of government, with the judiciary trying to ensure constitutional protections, while the executive branch argues for the flexibility needed to enforce immigration law. The case also demonstrates how emergency litigation at the Supreme Court can reveal deep philosophical differences among the justices about the role of courts in checking government power. The stark divide between Justice Sotomayor's view that the court was enabling government lawlessness and the majority's apparent view that the government's concerns about operational disruption justified immediate relief reflects broader debates about judicial power and constitutional enforcement. What happens next? As this case moves forward, it will likely have significant implications for immigration law and the scope of federal court power. The ultimate resolution of whether district courts have jurisdiction to issue class-wide relief in immigration cases could affect thousands of individuals and fundamentally reshape how constitutional challenges to immigration enforcement are litigated. The case also serves as a test of how the Supreme Court's decision in CASA will play out in practice. Will the requirement that broad relief go through Rule 23 class actions provide meaningful protection? Or will it prove to be more of a procedural hurdle that doesn't substantially change outcomes? Closing thoughts. The DVD case represents a fascinating collision of constitutional law, immigration policy, and judicial power. It forces us to grapple with fundamental questions about what process the Constitution requires when the government wants to send someone to a country where that person might face torture or death. Whether the government's concerns about operational efficiency and diplomatic relations outweigh individual due process rights, or whether Justice Sotomayor's concerns about government lawlessness and constitutional violations should carry the day, remains to be seen. What's clear is that this case will likely have lasting implications for how we balance individual rights against government power in the immigration context. That's our deep dive into Department of Homeland Security versus DVD. As always, I encourage listeners to read the opinions themselves and form their own conclusions about these complex constitutional questions. Thanks for joining me on SCOTUS Oral Arguments and Opinions, and I'll see you next time for another journey into the fascinating world of Supreme Court jurisprudence. Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Talk to you soon.